Hi, I'm Steve Carlson. I'm going to bring to you a draft of a filing I'm going to make with the Minnesota Supreme Court, trying to straighten out this whole train wreck established by Al Franken in swooping down like the fox in the Chickenhouse to ruin any possible operation of the comprehensive congressional election code established by the Minnesota State Legislature, as all states must do, under Article 1, Section 4 of the United States Constitution. And this is a draft, but I want to get this out as soon as possible so people can know what Franken is trying to pull here. It's the same thing he tried to pull in 2009 against Coleman. He tried to stop the contest before it was over and get the certificate of election from the governor at that time, Tim Pawlenty. Now, Pawlenty was a Republican and was not willing to give Franken the certificate over Norm Coleman from his own party. And so they went to court. In this case, you've got a little song and dance between Ritchie, who was also involved with the Franken case, but he wasn't the governor, and also Pawlenty, who was the governor, but at this time it's Dayton, and he's dancing a song and dance with Franken and Ritchie to get this illegal certificate of election hustled out to Washington and to destroy basically the proceedings here. So I'm arguing that they're voidable, and there's been some argument on that. It's going back from the panel to the Minnesota Supreme Court at this point, who will decide whether or not you can't void this kind of thing, because there's some kind of special rules that once this happens, you just got to let it be. Well, for arguments I'm going to make in this partial draft, my position is that no, you can't just let it be, as it were, in this case. Pursuant to 209.10 subdivision 4, contestant Steve Carlson appeals the attached ruling of the 3-judge panel appointed by this court in the matter of choosing a U.S. Senator from Minnesota in the 2014 general election. Said ruling denying contestants' post-judgment motion to void the proceedings and judgment and basically to go on with this contest as the law requires. Contestant Senate nominee 2014 Carlson files this appeal from the denial of post-judgment motions by the panel appointed by this court on the grounds that it departs from the solid principles and precedents of Minnesota's complete congressional election code, I also refer to as CCEC, as established, these principles established in the 2009 case Franken versus Pawlenty before this very Supreme Court, and in Smiley versus Holm before the U.S. Supreme Court, Rodebush versus Hartke before the U.S. Supreme Court, and discussing how this violated 204C.40 subdivision 2, which says you cannot issue a certificate when a contest is still pending. And also the Nixon versus United States case that talked about the power of the Senate, and also a Gamage case that involved, his name is Gamage, who ran against Ron Paul in 1977. So here are the grounds. Number one, the panel's action continues to violate the state's complete congressional election code. The ruling would establish pernicious public policy violating the U.S. Constitution and law, and the panel's argument for application of a temporal mandate, a rush, a haste, is not justified and violates the U.S. Constitution. Also contradicts their findings in the Pawlenty case. So to begin, the new preeminent congressional election contest criteria pronounced in the ruling, and specifically Vandenorth wrote, the central purpose of congressional election contests, the efficient and decisive issuance of a certificate of election, and that's from the order at 13, that this deprives these criteria deprive contestant and the people of the state of Minnesota generally of the, quote, numerous requirements as to procedure and safeguards which experience shows are necessary in order to enforce the fundamental right involved, unquote, which comprise and are mandated to comprise the state's CCEC. And by the way, the vote count itself is not the fundamental right involved. It's really the vote. And I also say see Smiley versus Holm, 285 U.S. 355 at 366, a 1932 case from the United States Supreme Court, and Rodebush versus Hartke, 405 U.S. 15 from 1972 from the U.S. Supreme Court. So Franken is coming down and violating all these U.S. U.S. Supreme Court cases, and I'm thinking he used to be on the U.S. Senate Judiciary Committee, and sometimes has chaired that. And he comes down. He should know better than doing this. Now the CCEC, that's Comprehensive Congressional Election Code, again, this is for congressional elections, not the rest of the state elections. Anyway, they are established in Minnesota under Section 4, and it requires that arbitrary, capricious, and deformed proceedings as occurred under Franken's motion to dismiss can be voided, and recertification of Al Franken sought. Void, invalidate his certificate, and make him go back into the court in the contest to complete it under Minnesota law, rather than trying to avoid it and shut it down. Now, the CCEC established in Minnesota requires this. Now, beyond that, neither the panel, a three-judge panel appointed by the Supreme Court itself, who now it's coming back to, nor the Supreme Court have the power to limit the operation of the CCEC within the ambit of the numerous requirements as to procedure and safeguard, which experience shows are necessary in order to enforce the fundamental right involved. Again, citing Smiley. And the biggest problem here, as the notice of contest carefully explains generally, is that this court does not meet these constitutional requirements in the United States Constitution and pronounces narrow obligations under the code, such as just counting the votes and just ballot issues. Perhaps the clearest case in a congressional contest is Franken's own case, which the order calls Palenti, Franken versus Palenti, and which Franken obviously took as a carte blanche to violate these requirements at will, and for his Democratic Farmer Labor DFL party to violate them at will, and allowing him to reach across the aisle with the Republicans to bar the Independence Party from all his debates. And here's a footnote. And Mark Dayton, who illegally issued Franken a certificate of election December 19th, also took the hint, apparently from your case, that he could use the Independence Party nominee Hannah Nicollet in debates against Jeff Johnson when he felt she should be included. This deteriorated into a new rule this court pronounced, again erroneously, in my petition this summer, that the Independence Party as a major political party did not need to be invited to participate in publicly broadcast debates governed by the equal protection requirement, but also by the First Amendment in CCEC. This court, through its negligence and disregard for the First Amendment and the CCEC the legislature passed, or the equal protection requirement in the federal law, has ushered in a new era, democracy by invitation only. This is a shallow farce of the democracy our Constitution not only requires, but without which we may not continue to exist as a nation. That means we won't be permitted to, won't be allowed to, will not be able to. This is not sound and fury signifying nothing, as Franken jokes in court filings. Now, out of that particular footnote. Now, to go on, the ruling to the second ground, the ruling would establish pernicious public policy violating the U.S. Constitution and the law. And just a short introduction on that, upholding this unconstitutional reading of the CCEC would establish an unconstitutional and pernicious public policy encouraging candidates for Congress to establish, or you could say for any legislative office, including Minnesota state legislature, to establish baseless temporal goal lines, time goal lines, to move the ball across, to moot any questions regarding their right to office where serious, deliberate, material violation of Minnesota election provisions are set out as points in the election contest. Now, under the United States Constitution, the United States Supreme Court has held in a Minnesota case, that's Smiley versus Holm in 1932, which determined whether the sitting governor could veto congressional redistricting plans passed by the state legislature. Actually, just the legislature sitting as an agent for the framers, people way back in 1789 at the Philadelphia Convention. And they have held, the Supreme Court, that Section 4 of Article 1 mandates the Minnesota legislature to prescribe, that means establish in advance and then follow, a complete congressional election code. All right, and then the third ground will be the panel's argument for application of a temporal mandate is not justified and violates the U.S. Constitution. Now, just a few facts in this draft. In his 2008 Senate race, Al Franken, upon receiving a new count by the state canvassing board, contested Al Franken in an election by bringing an election petition filed with this court, the Minnesota Supreme Court, under 204B.44, to obtain an election certificate while the contest under State Law 209 was pending. Franken filed that contest through the automatic recount provision, but he put before this court, Minnesota Supreme Court, his demand that he be immediately issued the election certificate in his race against Norm Coleman, the Republican incumbent, even before the contest under Minnesota law was finally determined. As in this case, he asserted rights that are not found in Minnesota election contest law. As in this case, Franken was actually challenging and attempting to subvert the Minnesota CCEC, the Comprehensive Congressional Election Code. And now that he got the certificate from Governor Dayton, December 19th, and presented it to the Secretary of the Senate, who relied on that to seat him, and that is, according to the letter from the Secretary of the Senate, submitted as Exhibit A by the Secretary of State in trying to derail this contest. Franken now claims that everything is moot. That means we don't need to talk about it anymore. Because while before the governor illegally issued his election certificate, December 19th, 2014, let me just describe how that happened. On December 18th, a trial consisting largely of Franken's motion to dismiss the entire contest lasted to about 1:30 p.m. that afternoon. That afternoon, the three-judge panel signed an order granting his preliminary order. It was not given to me, the order was not, or noticed to me. The afternoon of the 19th, Mark Dayton and Mark Ritchie signed and sealed an election certificate and cover letter from Dayton claiming that 204C.40 subdivision 2 had been complied with. And that's the one that bars the issuance of the certificate as long as the contest is still going on, and this contest was still going on. And Nathan Hartshorn, the Attorney General, with Lori Swanson, stated March 23rd in open court that, yes, Franken did take that certificate up to Washington. Thus, unbeknownst to me, when I appealed and sought mandamus in this case on December 26, 2014, insofar as Chapter 209 proceedings, this contest had already been finally determined December 19th, but I was given no notice of it. Not until I received the briefs of contestees Franken and Ritchie on or after January 5th, 2015, did I realize that Dayton and Ritchie had quietly signed, sealed, and sent this unlawfully issued certificate to Washington. So the fact that just as the Senate was acting on Minnesota's seating in the Senate, January 6th, this court had some sudden interest in discussing this procedure of illegally issuing the certificate is totally irrelevant. and the only recourse is to void the entire proceeding, and Franken must be recertified according to our law. Out of that footnote. So, but before he got that certificate, Franken argued that this panel, this three-judge panel appointed by the Supreme Court, had all this power to totally dismiss the contest. And here's a footnote, and this court told Franken he had to have this motion inimical and not merely antithetical to the contest provision before the panel and decided by the panel. So this court told the panel to hear a motion to dismiss the whole contest. What if Coleman had been allowed to do the same? I'd like to introduce Henrietta, my parrot, who is talkative today. And so they supposedly had all this power, but to hear his motion. Now, he took that motion which said, dismiss this whole thing, which is unhearable, but they still sent it down to the panel, and he changed it in a private letter to the panel on the 16th of December, just like 2 days before the hearing, and I never got it. It was discussed at the outset of the hearing, to just limiting his motion to just give him the election certificate and forget the rest. And surprisingly, they complied. Now, then this court, the Supreme Court, erroneously ruled on January 5th that the contest was finally determined. They said judicially determined. But the Senate also sits in the judicial capacity, so that's inaccurate. Now, this view expressed in the Supreme Court's January 5th order is erroneous on 2 counts. One is after the certificate was issued, while all other issues were reserved by the panel as far as the U.S. Senate is concerned, the Chapter 209 proceeding had already been finally determined insofar as Minnesota could do it under 209.12. And again, it needs to be voided and done right. And the Senate was not expecting anything else from the state when they acted to seat Franken illegally. And 2, the panel failed to determine the contest under the whole CCEC contest provision 209.12. The whole provision, not just one sentence. This is the very same provision which Franken argued here before that should not stop the issuance of the certificate in the Coleman election. This focused on 209.12 and 204C subdivision 2. In that case, he concentrated on subdivision 1, which of course was totally irrelevant. And you can look at the Supreme Court's opinion there to get more information on that. But this time, then, the fox got the chickens. He got the certificate because the CCEC was not followed. If it was followed, if the law was followed, the fox is still out of the chicken coop without chickens. Al Franken is still going through this contest, which he does not want to go through. Now the issue is there a remedy in the code? And I argue there is. And it is to void the entire proceeding and recertify Al Franken according to Minnesota law, which will require continuation of the contest under 209.12. And I also, I'm going to leave out that particular footnote right now. This is just a draft. Now, Al Franken's 2009 petition was based on extremely shaky grounds, legal grounds, indicating that as a wealthy entertainer, he had plenty of money to throw the kitchen sink at the Minnesota courts to bull his way into the Senate. And I know even Republicans agree with that. Okay? This court correctly and with thorough documentation in that case rebuffed his aggressive tactics, as I will explain as relevant infra, but not at length in this draft. However, in response to the instant contest, Franken caused, with all due respect, a train wreck, which blocked the contest. This court improperly aided Franken in bringing a motion to dismiss to the panel, to disrupt and obfuscate the proceedings by taking up the limited time with this motion to dismiss that has no place in an election contest. The role of the panel is very clear in the CCEC. In addition to making findings of fact and conclusions of law on the unchallenged issue of the vote count, it is to collect and certify evidence to send to the Senate. Again, in this case, of serious, material, deliberate violation of the Minnesota Election Code. And I think that Al is establishing a pattern of this. This is just how he does business. The Secretary, and I want to include this footnote. Contestant, that's me, is aware that the 2009 Franken case, Franken versus Pawlenty, which the panel calls Pawlenty, has been used to create the false impression that the only purpose of a congressional election contest under Minnesota's CCEC is to correct errors or irregularities in tabulating the vote. And further, this court, I'm also aware this court has abused that case of Franken's to limit petitions as well as they are governed, and as they are governed by the CCEC, as if you can only address ballot issues. You know, how did you spell the name? What order did you put the name in? The kind of things that always come up in state cases, but we certainly hope wouldn't come up in a Senate case for the United States Senate. Now, this clearly violates Article 1, Section 4, this limiting of it by the Supreme Court of the U.S. Constitution. And vote counts was the only issue in Rodebush, which is the case that Franken and the court there actually discussed. And in Franken's first contest against Coleman in 2009, it was all about vote count. Very famous case. Coleman won, but then the state canvassing board reversed the numbers, and then Franken won, and it was this whole contest that Franken wanted to just get to the Senate real quick. He made these ridiculous arguments like that. There's 2 senators from Minnesota, therefore he has to run up there right away. I don't know how this guy ever got into Harvard, quite frankly, not meaning to be negative. It's just surprising the kind of arguments that he would bring. I mean, you can see from his arguments with people like Bill O'Reilly or Ann Coulter just how he, quote-unquote, reasons or argues. He basically just wants to push. And he's pushed here illegally and unconstitutionally. And this is completely erroneous. This position by the court that you can only deal with ballot issues, completely erroneous, if not actually disingenuous, on the part of this court. For in the same Franken contest, in which he sought to, which he, in his petition, he brings a petition seeking to shut down the contest, to short-circuit it, to block it, to curtail. By this election petition he filed against Pawlenty and Ritchie and Coleman. But this very Supreme Court cited at length the enumeration by Chief Justice Hughes of the U.S. Supreme Court in Smiley, which says it has this broad range that's all included in that little phrase of the time, place, and manner, which needs to be prescribed by the legislature according to Article 1, Section 4. And by the way, if you're not in Minnesota, your state has exactly the same requirements for your legislature to set up these election laws for the federal government. Some people may not be totally aware of that, so I'm just bringing that up. So, nonetheless, the panel I'm appealing from, erroneously cited this very Pawlenty case as providing that the only role of a congressional contest is to determine the vote count. And then they incredibly assert that this alone, without the circumstances required by 204C.40 subdivision 2, that is to say that the contest has been finished. If it hasn't been finished, you can't send a certificate. And somehow now that panel is supposedly arguing that this that just the vote count determines the whole contest. And yet Franken changed it so they would only look at 2 sentences and would not be allowed, according to his motion, which apparently they accepted. They never came out and say, yeah, we'll only look at the 2 sentences. But in fact, that is all they looked at. And that was his motion. He would get that and get out of there with the certificate. And now they're saying that, yeah, it's just based on vote count, and they got that from this Minnesota Supreme Court. That is totally erroneous and unconstitutional. Now, Secretary of State Mark Ritchie and Franken's legal teams misled both this court and the panel. That's by going first to the Supreme Court and down to the panel, now back to the Supreme Court, into granting this improper motion to just look at 2 sentences based on a letter from the Secretary of the U.S. Senate. And this is Exhibit 1, Ritchie's answer to the notice of contest, which I've shown in some of my previous videos, which they claimed created an urgency, which this court, in denying Franken's 2009 attempt in Palenti, said does not exist. This urgency does not exist under either state or federal election law. So the panel has erred and unconstitutionally barred the working of the CCEC, established by the Minnesota legislature under Article 1, Section 4 of the Constitution. Now, in addition to conjuring up this supposedly preeminent Minnesota state policy of haste, and they have no authority for that, in an election contest for the U.S. Senate, in denying the post-judgment motions properly filed by contestant, the panel of 3 judges sought to insulate their voidable and erroneous decision to grant Franken the certificate by cherry-picking those parts of the Civil Code. Sorry about that. We had a fire here recently. Those parts of the Civil Code they would apply to this election contest. And they violated the purpose and mandate of Minnesota's CCEC, the Comprehensive Congressional Election Code. To be very blunt, voiding an unconstitutional panel proceeding like this one is completely consistent with and promotes the purpose of an election contest. Under both Sections 4 and 5 of the United States Constitution, Article 1. This is exactly the kind of political corruption and abuse of election procedures that the United States Constitution was intended to protect America against. If a political operator like Franken can come into a contest and subvert it by this kind of slick and illegal procedure, like Franken, as Franken and Ritchie and Dayton have followed here, to allow him to then turn around and cry moot as soon as he gets to the U.S. Senate to seat him while the contest is pending at St. Paul, Minnesota courts, this would make our democratic republic impossible. Further, the other piece that allowed Franken to ram this travesty of undemocratic injustice through was a letter sent privately to the panel December 16th, but not to me, which limited his motion even more narrowly to just fit the stratagem he had attempted in this Minnesota Supreme Court in 2009. Thus, the panel has never even considered the scope of the contest required by the CCEC. And I'm going to then include a procedural history of what has happened here, which basically says that the Supreme Court improperly helped Al Franken cause this train wreck by violating the purpose and repeatedly applying procedures inconsistent with the CCEC. The panel you appointed took over there with the conductor, Judge Vandenorst, actually opening the so-called trial with the actual statement, let's get this railroad moving. And I'm saying, let's get America back on track again. So, 2 points of view. I don't want a railroad. I want democracy in America restored and back on track. And that's why I oppose Al Franken. I'm Steve Carlson, and I approve this message.